I never thought I would spend my 35th birthday sitting in a county courthouse staring at a land patent signed by President Ulysses S. Grant. But life has a funny way of throwing curveballs. My name is Vincent Bradley, and this is the story of how my family's 160-acre ranch in Millerton County, Texas, became ground zero for the worst homeowner association nightmare you could imagine. The whole thing started on a Tuesday morning in late March when I drove out to my grandfather's property to check on things. Grandpa Earl had passed away 6 months earlier, leaving the ranch to me in his will. The land had been in our family since 1873, passed down through generations of Bradleys who worked the soil, raised cattle, and lived simple lives away from the chaos of modern development. I had planned to eventually move there myself, build a house, maybe start a small organic farm. The property sat just outside the town limits of Riverdale, Texas, a growing community about 40 miles north of Austin that had exploded in population over the past decade. As I turned off Highway 183 onto the old dirt road that led to the ranch, something felt wrong immediately. The familiar landscape looked different. Where there should have been open fields and the old oak trees that marked the property line, I saw construction equipment. Lots of it. Bulldozers, cement mixers, framing materials stacked in neat piles, and townhomes, actual townhomes, maybe 3 stories tall, modern-looking with their gray siding and black trim, lined up in neat rows like soldiers. I slammed on the brakes, dust billowing around my truck. My heart pounded as I counted them. 15, 20, 30 townhomes already standing, more foundations poured and ready for framing. The construction site stretched across at least 30 acres of what was supposed to be my land. A security guard approached my truck before I could even get out. He was young, maybe early 20s, wearing a yellow vest and carrying a clipboard. "Sir, this is private property, construction zone. You need to turn around," he said. I rolled down my window, trying to keep my voice steady. "This is my property. I own this land." He looked confused, glancing down at his clipboard. "No, sir, this is the Meadowbrook Hills development, property of the Meadowbrook Hills Homeowners Association. You must be mistaken." "I am not mistaken," I said, pulling out my phone. "My grandfather owned this ranch for 50 years. He died in September, and I inherited it. Every acre you are standing on belongs to me." The guard shifted uncomfortably. "Look, I just do security here. You need to talk to the HOA office. They have a temporary trailer set up on site. Down that way, past the completed units." I followed his directions, my hands shaking on the steering wheel. This had to be some kind of massive mistake, some surveying error. There was no way someone could just build 40 townhomes on land they did not own. That did not happen in America, not in the 21st century. The HOA trailer sat at the far end of the development, a double-wide temporary structure with a banner reading Meadowbrook Hills Sales Office hanging across the front. I parked and stormed inside without bothering to compose myself. A woman in her late 40s sat behind a desk, talking on the phone. She had the kind of haircut that screamed, "I want to speak to your manager," shoulder-length blonde hair with highlights, perfectly styled. She wore a blazer over a floral blouse and had reading glasses perched on her nose. When she saw me enter, she held up one finger in a "wait a minute" gesture that made my blood boil. "Yes, Mrs. Patterson, I understand your concerns about the playground equipment," she said into the phone, her voice sugary sweet. "We will have that addressed at the next board meeting. Thank you for being such a vigilant member of our community." She hung up and smiled at me, the kind of smile that did not reach her eyes. "Good morning. Welcome to Meadowbrook Hills. Are you interested in purchasing one of our luxury townhomes? We have 3 units still available, priced competitively at $475,000 each." "I am not here to buy anything," I said, planting my hands on her desk. "I am here because you are building on my property. This entire development is sitting on my grandfather's ranch." Her smile disappeared instantly, replaced by a look of irritation. "Excuse me? This land belongs to me, Vincent Bradley. My grandfather was Earl Bradley. This has been our family ranch since 1873. She stood up, straightening her blazer. "I am Sharon Mitchell, president of the Meadowbrook Hills Homeowners Association. I can assure you that we have done our due diligence. This land was purchased legally through a county tax sale 2 years ago. We have all the proper permits and documentation." "A tax sale?" I felt like the floor had dropped out from under me. What are you talking about? Sharon pulled a file from her desk drawer, flipping it open with practiced efficiency. The property at 14,500 County Road, 492, was seized by Millerton County for non-payment of property taxes in 2023. After the required notification period with no response from the owner, the land was auctioned at a public tax sale. The Meadowbrook Development Group purchased it and subsequently transferred ownership to the Meadowbrook Hills HOA upon completion of the first phase of construction. That's impossible, I said. My grandfather always paid his taxes, every year, like clockwork. The county has records showing 3 years of delinquent taxes, Sharon said, her tone suggesting she had this conversation before and found it tiresome. Perhaps your grandfather's health was declining and he forgot to pay. It happens with elderly property owners more often than you would think. Regardless, the legal process was followed. This land belongs to Meadowbrook Hills now. I wanted to scream. I wanted to flip her desk over. Instead, I forced myself to take a deep breath. I need to see those records. This does not make any sense. My grandfather was meticulous about this stuff. You are welcome to visit the county tax assessor's office, Sharon said, sitting back down and returning her attention to her computer screen, clearly considering the conversation over. Now, if you will excuse me, I have work to do, and you are trespassing on HOA property. I'm not going anywhere, I said. Not until we figure this out. Sharon picked up her phone. Gary, we need security at the sales office. We have a trespasser refusing to leave. She looked at me with cold eyes. You have 2 choices, Mr. Bradley. Leave voluntarily or be escorted off the property by security and potentially arrested for trespassing. The young security guard from earlier appeared at the door, looking distinctly uncomfortable. Sir, I'm going to have to ask you to leave. I held up my hands. I am going. But this is not over. Not even close. As I drove away, my mind raced. Something was deeply wrong here. Grandpa Earl had been sharp as a tack until the very end. He had managed his finances with the precision of a former accountant. There was no way he had forgotten to pay property taxes for 3 years. No way. I headed straight to the Millerton County Tax Assessor's office in the county seat of Whitmore. The office was in the old courthouse building, a limestone structure that had stood since 1892. Inside, fluorescent lights hummed overhead as I approached the counter, where a tired-looking woman in her 60s was processing paperwork. I need to see the tax records for a property, I said, trying to keep my voice calm. 14,500 County Road, 492, Riverdale. She typed into her computer, squinting at the screen. The Earl Bradley property? That went to tax sale in July 2023. Can you show me the payment history and the notifications that were sent before the sale? She clicked through several screens, then printed out a stack of papers. Here you go. Shows the last payment received was in 2019. Taxes for 2020, 2021, and 2022 went unpaid. Notices were mailed to the property address in January, April, and July of each year. When no payment or response was received by June 2023, the property was scheduled for the July public auction. I scanned the documents, my confusion growing. Wait, the notices were mailed to the property address? My grandfather did not live on the property. He lived in town, at 428 Maple Street in Riverdale. That is where his mail went. The clerk checked her screen again. The mailing address on file shows 14,500 County Road, 492. When was it changed to that address? More typing. Looks like January 2020. A change of address form was submitted. By who? Does not say. Just shows the change was processed on January 14th, 2020. The pieces were starting to fall into place, and I did not like the picture they were forming. Can I get copies of everything? The payment history, the address change documentation, the auction records, all of it? That will be 50 cents a page. Looks like about 40 pages total. I paid the $20 and left with a thick folder of documents. Sitting in my truck in the courthouse parking lot, I went through everything methodically. The last tax payment from Grandpa Earl had been in December 2019 for that year's taxes. In January 2020, someone had submitted a change of address form for the property. The form itself was not in the copies, just a notation that the change had been processed. After that, all tax bills and delinquency notices had been sent to the ranch address, where there was no mailbox, no way for anyone to receive them. Grandpa Earl, living in town, would have had no idea the bills were not arriving, no idea he was being declared delinquent. In July 2023, the property had been sold at auction for $98,000 to something called Meadowbrook Development Group, LLC. For 160 acres of prime land outside a rapidly growing town, that was highway robbery. Properties in that area were worth at least $10,000 an acre, probably more. I needed help, and I needed it fast. I called my friend Marcus Chen, a real estate attorney I had gone to college with. We had kept in touch over the years, and I knew he worked for a firm in Austin that handled property disputes. "Marcus, I need your help. Like yesterday," I said when he answered. "Vincent? Hey man, what's going on?" I explained the situation as quickly as I could. When I finished, there was a long pause on the other end. "That is seriously messed up," Marcus said. "The address change is the key. If someone fraudulently changed the mailing address to prevent your grandfather from receiving notice, the tax sale could be invalid. But you will need to prove it was fraudulent, and you will need to move fast. How long ago did your grandfather pass away?" 6 months, September 8th. "And you have been the legal owner since then through probate?" "The will just finished probate last month. The property officially transferred to my name on February 20th. "Okay. So you are the current legal owner according to probate records, but these people are claiming ownership through a tax sale that happened before your grandfather died. This is going to be complicated. We need to file a lawsuit to challenge the tax sale and get an injunction to stop any further construction. Can you come to my office tomorrow morning?" "I will be there at 8. That night, I barely slept. I kept thinking about Grandpa Earl, about how hard he had worked to maintain that land, to keep it in the family. He had been so proud when he told me he was leaving it to me, had made me promise to take care of it. And somehow, while he was still alive, someone had stolen it out from under him. At Marcus's office the next morning, we went through all the documentation. Marcus was a sharp guy, early 30s like me, with dark hair and sharp features that made him look like he belonged in a courtroom. He examined every page with careful attention. "The Tina. The address change is definitely suspicious," he said. "But here's the thing. The county followed their legal process. They sent notices to the address on file. They published the tax sale in the newspaper. From their perspective, they did everything right. We need to prove that the address change was fraudulent, which means we need to find out who submitted that form. The county does not have a record of who filed it. Just that it was processed, but there should be an original form somewhere. It might have a signature. We need to subpoena the county records, get the original paperwork." Marcus leaned back in his chair. "But Vincent, I have to be honest with you. Even if we prove fraud, this is going to be a long, expensive fight. We are talking about a development with 40 townhomes, probably $20 million in value or more. They are not going to just walk away. I do not care how long it takes or how much it costs," I said. "That land is mine. It is my family's legacy." "There is one more thing we should look into," Marcus said, pulling up something on his computer. "Land patents. Your grandfather said the property has been in your family since 1873. That means your ancestor probably got it through a federal land grant or patent. If we can find the original land patent, that is an unbreakable chain of title going back to the federal government. It supersedes everything else." "How do we find that?" "The Bureau of Land Management keeps records of all land patents issued. If your family got the land through the Homestead Act or a similar program, there will be documentation. Let me make some calls." While Marcus worked the phones, I did some research on Meadowbrook Development Group. It was a limited liability company registered in Texas, but the ownership structure was murky. The registered agent was a corporate services company in Dallas. The more I dug, the more it smelled like a shell company designed to obscure who was really behind it. I also started researching property tax sales and was appalled by what I learned. Apparently, this kind of thing happened more often than I had imagined. Investors would watch for properties going into tax delinquency, sometimes even filing fraudulent address changes to make sure the owners did not receive notices. Once the property went to tax sale, they could buy it for pennies on the dollar. It was legal theft, predatory, and disgusting. By late afternoon, Marcus had news. Okay, I found it. Land patent number 8472, issued on March 15, 1873, to Samuel Bradley under the Homestead Act. 160 acres in what was then Travis County, now Millerton County. I am having certified copies sent overnight. Is that good? Does that help us? It is very good, Marcus said with a slight smile. A land patent is the original grant of title from the United States government. It is the foundation of all property ownership in this country. The patent gives us an unbroken chain of title from the federal government through your ancestors to you. It is one of the strongest forms of evidence in a property dispute. So we can prove I own the land. We can prove your family has owned the land continuously since 1873. The question is whether the tax sale legally broke that chain of ownership. That is what we need to litigate, but having the patent puts us in a much stronger position. It shows this is not just some property. This is homestead land that has been in your family for 5 generations. Marcus filed the lawsuit the next day in Millerton County District Court. We sued the Meadowbrook Hills HOA, Meadowbrook Development Group LLC, and Millerton County, seeking to void the tax sale and quiet title in my name. We also filed an emergency motion for a temporary restraining order to halt all construction on the property. The hearing for the restraining order was scheduled for the following Monday. That gave me a few days, which I used to dig deeper into what was happening. I drove back out to the development and took hundreds of photos, documenting everything. I also started talking to some of the people who had already moved into the completed townhomes. Most of them were young professionals, couples who worked in Austin and wanted a more affordable place to live outside the city. They had paid between $400,000 and $500,000 for their units. When I explained the situation, that the HOA might not actually own the land, their reactions ranged from disbelief to panic. We closed 2 months ago, one woman named Jennifer told me. She was standing in her doorway, her face pale. We used our entire life savings for the down payment. Are you saying we might not actually own our home? I'm saying the HOA might have built on land they did not have the right to build on, I said carefully. If that is true, I do not know what happens to the people who bought the units. I'm sorry. She slammed the door in my face, but I could not blame her. This whole situation was a nightmare for everyone involved, except maybe Sharon Mitchell and whoever was behind the development company. On Monday morning, Marcus and I arrived at the courthouse for the hearing. The courtroom was one of the older ones in the building, with high ceilings and wooden pews that creaked when you sat down. Judge Patricia Holloway presided, a stern woman in her early 60s with gray hair pulled back in a tight bun. The attorneys for the HOA and the development company were there, 3 lawyers in expensive suits from a big firm in Austin. They looked annoyed to be dealing with what they probably considered a nuisance lawsuit. The lead attorney, a man named Richard Caldwell, spoke first. Your Honor, this is a frivolous attempt to interfere with a lawfully completed real estate transaction. My clients purchased this property through a legitimate county tax sale after the previous owner failed to pay property taxes for 3 years. The county followed all required procedures. The plaintiff has no grounds to challenge the sale. Marcus stood up. Your Honor, we have evidence that the tax sale was procured through fraud. Someone changed the mailing address for the property in January 2020, causing all tax bills and delinquency notices to be sent to an address where they could not be received. The property owner, Mr. Bradley's grandfather, had no notice of the delinquent taxes or the impending sale. Additionally, we have obtained the original land patent for this property, issued in 1873 under the Homestead Act. This document establishes an unbroken chain of title from the United States government to my client. The purported tax sale cannot supersede federal land patent rights. That got Judge Holloway's attention. She looked up from the papers she had been reading. You have the original land patent? Yes, Your Honor. Certified copy from the Bureau of Land Management. Marcus handed a document to the bailiff, who passed it to the judge. Judge Holloway examined it carefully, her expression unreadable. Then she looked at the opposing attorneys. Mr. Caldwell, Does your client have any documentation regarding how the mailing address for this property was changed in 2020? Caldwell looked uncomfortable. Your Honor, my clients purchased the property in good faith at a public auction. They had no involvement in any address changes. If the county made an error in their notification process, that is an issue between the plaintiff and the county. The county is also a defendant in this case, Marcus pointed out. We are seeking to hold all parties accountable. The county's attorney, a young woman who looked fresh out of law school, spoke up nervously. Your Honor, the county followed all statutory requirements for tax sales. We sent notices to the address on file and published the required notices in the newspaper. But you cannot produce the original change of address form, the judge asked. We are still looking for it, Your Honor. The notation is in our computer system, but the original paper form has not been located yet. Judge Holloway was silent for a long moment, studying the documents in front of her. Finally, she spoke. Here is what I'm going to do. I'm granting a temporary restraining order halting all construction on the property until this matter can be fully litigated. The land patent raises serious questions about the validity of the tax sale, and the missing documentation regarding the address change is troubling. This case needs a full evidentiary hearing. I'm scheduling a preliminary injunction hearing for 3 weeks from today. In the meantime, no further construction will take place on the disputed property. The HOA attorneys immediately objected, arguing that stopping construction would cause massive financial harm to their clients. Judge Holloway was unmoved. If your clients built on property they did not have valid title to, that is their problem, not the plaintiff's. The temporary restraining order stands. As we left the courtroom, Marcus was cautiously optimistic. That went better than I expected. Holloway is a tough judge, but she is fair. The land patent definitely got her attention. What happens now? Now we prepare for the preliminary injunction hearing. We need to gather all the evidence we can about the fraudulent address change. We should also depose everyone involved with the development company, find out who is really behind it, and we need to document the entire chain of title for your family's ownership of the property. The temporary restraining order infuriated Sharon Mitchell. The next day, I received a certified letter from her, written on HOA letterhead, threatening to sue me personally for tortious interference with business relationships and demanding I drop the lawsuit immediately. Marcus just laughed when I showed it to him. Empty threats. Let her sue. It will just give us more discovery. But Sharon was not done. Over the next week, she started a campaign of harassment that would have been funny if it were not so aggravating. She showed up at my apartment in Austin, banging on my door at 7 in the morning, demanding I speak with her. When I refused, she started calling me at all hours, leaving increasingly unhinged voicemails about how I was destroying people's lives and ruining their investment. She also organized a meeting of the HOA residents, telling them that I was trying to steal their homes. Several of them started sending me angry emails and messages on social media. I understood their fear, but it was misdirected. I was not the one who had built townhomes on stolen land. Marcus's paralegal, a sharp woman named Rita, started digging into the development company's background. What she found was disturbing. Meadowbrook Development Group LLC had been formed just 3 months before the tax sale in April 2023. The sole member listed was another LLC, which was owned by another LLC, creating a maze of corporate entities that was clearly designed to hide the true ownership. But Rita was persistent. She traced the corporate chain through 6 different entities until she finally found the name of a real person, Gregory Hoffman, a real estate developer from Dallas with a history of questionable deals. More digging revealed that Gregory and Sharon Mitchell were siblings. The whole thing was a family operation. Even more interesting, Rita found that Sharon had worked for the Millerton County Tax Assessor's Office from 2018 to 2020. She had access to all the property records. She would have known exactly which properties were delinquent on taxes and could have easily filed change of address forms. This is gold, Marcus said when Rita presented her findings. Sharon worked in the tax office, changes the address on your grandfather's property, then conveniently her brother's company buys it at the tax sale for a fraction of its value. This is conspiracy and fraud, clear as day. We filed an amended complaint adding Gregory Hoffman as a defendant and including detailed allegations of fraud and conspiracy. We also sent all the information to the Millerton County District Attorney's Office, suggesting they might want to investigate potential criminal activity. The preliminary injunction hearing arrived on a warm April morning. The courtroom was packed. All the townhome residents were there, along with Sharon and Gregory, their attorneys, representatives from the county, and even some reporters who had gotten wind of the case. Marcus had prepared meticulously. He had organized all our evidence into clear exhibits: the land patent, the chain of title documents, the suspicious address change, Sharon's employment history, the corporate structure of the development company, everything. The hearing lasted all day. Marcus called me as the first witness, and I testified about my grandfather, about his meticulous attention to his finances, about how he had always paid his taxes on time. I described finding the construction on the property, my shock and disbelief. "Mr. Bradley, how long had your grandfather owned this property?" Marcus asked. He had owned it for 50 years, but it had been in our family for 152 years before that. My great-great-great-grandfather Samuel Bradley homesteaded that land in 1873. "And was your grandfather the kind of man who would forget to pay his property taxes for 3 years?" "Absolutely not. He was a retired accountant. He kept detailed records of everything. He would have noticed immediately if tax bills stopped arriving." The opposing attorneys tried to poke holes in my testimony during cross-examination, suggesting that elderly people often become forgetful, that maybe my grandfather's health had declined more than I realized. But I held firm. I knew Grandpa Earl. He had been sharp until the day he died. Next, Marcus called a handwriting expert who had examined the change of address form that the county had finally managed to locate. The expert testified that the signature on the form did not match any known samples of my grandfather's signature. "Easy. In my professional opinion, this signature is a forgery," the expert said. Then came the bombshell. Marcus called Sarah Chen, a former colleague of Sharon's from the tax assessor's office. Sarah testified that Sharon had talked frequently about wanting to get into real estate development, about how she knew which properties were going to tax sale and saw it as an opportunity. She said the job was boring, but it gave her inside information, Sarah testified. She specifically mentioned ranch properties outside Riverdale as being undervalued and ripe for development. The opposing attorneys objected strenuously, but Judge Holloway allowed the testimony. When it was the defense's turn, they called Sharon Mitchell to the stand. Marcus had subpoenaed her, so she had to appear. She looked composed but angry, dressed in another blazer and skirt combination, her blonde hair perfectly styled. Richard Caldwell, her attorney, questioned her first, letting her tell her version of events. According to Sharon, she and her brother had simply made a smart investment. They had been watching properties going to tax sale, had purchased the land legitimately, and had done everything by the book. "Did you have anything to do with the change of address for the Bradley property in January 2020? Caldwell asked. "Absolutely not," Sharon said firmly. "I do not even remember that specific property from my time at the county office. I processed hundreds of forms." Then it was Marcus's turn to cross-examine her. He approached slowly, holding a thick folder. "Ms. Mitchell, you testified that you do not remember the Bradley property specifically. But is it not true that you pulled the file for this exact property in March 2020, just 2 months after the address was changed?" Sharon blinked. "I do not remember that." "Let me refresh your memory." Marcus handed her a document. "This is a file access log from the county system. It shows that your user ID accessed the Bradley property file on March 19, 2020, and again on April 2, 2020, and multiple times after that. Why were you accessing this file so frequently?" "I must have been responding to inquiries or processing routine paperwork," Sharon said, but her voice had lost some of its confidence. "What inquiries? What paperwork? Can you provide any documentation of these supposed routine matters?" "It was years ago. I do not remember the specifics." Marcus pulled out another document. "Is it true that you resigned from your position at the county tax office in May 2020, just a few months after making these mysterious file accesses?" "I resigned to pursue other opportunities." "And is it true that 1 month later, in June 2020, your brother formed Meadowbrook Development Group LLC?" "My brother's business activities are not my concern. But you are now the president of the HOA for the development built on land purchased by your brother's company. Is that just a coincidence? Sharon's face was red now. I am qualified to serve as HOA president. I have experience in real estate and community management. Marcus spent another hour methodically destroying her credibility, showing how she had accessed the file, how the address change had been processed during her tenure, how she had left the county job right before her brother formed the development company, how she had then taken over as HOA president. By the time he was done, Sharon looked shaken and furious. The hearing concluded with closing arguments. The opposing attorneys argued that even if there were irregularities in the address change, the tax sale itself had been conducted properly and could not be voided years after the fact. They argued that innocent purchasers, the townhome residents, would be harmed if the sale were overturned. Marcus made an impassioned closing that gave me chills. Your Honor, this case is about more than just a property dispute. It is about the sanctity of property rights in this country. The Bradley family has held this land continuously since 1873, when Samuel Bradley homesteaded it under a federal land patent. For 152 years, 5 generations of Bradleys worked that land, paid taxes on it, and maintained it. That chain of ownership cannot be broken by fraud. And make no mistake, this was fraud. Sharon Mitchell used her position of trust in the county tax office to identify vulnerable properties, changed the mailing address to prevent Earl Bradley from receiving notice, and then her brother swooped in to buy the land for a fraction of its value at a tax sale the owner did not even know was happening. This is exactly the kind of predatory behavior that courts exist to prevent. The land patent establishes my client's superior title. The fraudulent address change invalidates the notice requirements for the tax sale, and the evidence of conspiracy between the defendants demonstrates that this was not an innocent mistake, but a deliberate scheme to steal land. We ask the court to grant a preliminary injunction, void the tax sale, and restore title to Vincent Bradley, the rightful owner of this property. Judge Holloway took the matter under advisement, saying she would issue a ruling within a week. Those were the longest 7 days of my life. I could not focus on work. I could not sleep. I just kept thinking about Grandpa Earl, hoping I was doing right by him. The ruling came down on a Friday afternoon. Marcus called me immediately. We won. Holloway granted the preliminary injunction and made some very strong findings. She said there is clear evidence of fraud and that the land patent establishes your superior title. She is ordering the tax sale voided pending final resolution of the case. I felt relief wash over me like a wave. So it is over? Not quite. This is a preliminary injunction, not a final judgment. But it is a huge win. The other side will probably appeal, but Holloway's findings are going to be hard to overturn. And there is more. She referred the matter to the district attorney for criminal investigation. She specifically noted the evidence of conspiracy and fraud by Sharon Mitchell and Gregory Hoffman. The next few weeks were chaotic. The HOA's attorneys filed an emergency appeal, which was denied. The townhome residents, realizing they were caught in the middle of a fraud scheme, started filing their own lawsuits against Sharon, Gregory, and the development company. Several of them contacted me to apologize for the angry messages they had sent earlier. We did not know, Jennifer, the woman I had talked to earlier, said when she called me. We thought we were buying legitimate homes. I'm so sorry for what you went through. I understand, I said. You are victims here too. I hope you can get your money back from the people who did this. The Millerton County District Attorney, a no-nonsense prosecutor named Barbara Willis, moved quickly. In late May, her office filed criminal charges against Sharon Mitchell and Gregory Hoffman. Sharon was charged with forgery, fraud, conspiracy, and abuse of official capacity. Gregory was charged with fraud, conspiracy, and theft. The charges carried potential prison sentences of up to 20 years. The criminal proceedings moved separately from the civil case, but they reinforced each other. The DA's investigation uncovered even more evidence of wrongdoing. Sharon and Gregory had run this same scheme on at least 3 other properties in the county, though none as large as my grandfather's ranch. In each case, Sharon had used her access to county records to identify properties going delinquent, filed fraudulent address changes, and then her brother's company had purchased the land at tax sales. By August, Marcus and I were preparing for the final trial in the civil case. But before we got to trial, the defendants blinked. With the criminal charges hanging over them and the evidence stacked against them, Sharon and Gregory agreed to a settlement. They would deed the property back to me, pay all my attorney's fees and costs, and pay punitive damages of $200,000. The HOA would be dissolved. As for the townhome residents, Gregory's development company would be required to compensate them for their purchases and demolish the structures. It was not perfect. The demolition would take months and the land would need restoration. But the important thing was that the ranch would be back in my family where it belonged. The criminal trial happened in October. I attended every day, sitting in the back of the courtroom. The prosecution laid out the entire scheme in methodical detail. Sharon's former colleagues from the tax office testified about her suspicious behavior. Handwriting experts confirmed the forged signatures. Financial records showed money flowing from Gregory to Sharon right after each property was acquired. The defense tried to argue that the whole thing was a misunderstanding, that Sharon had made innocent mistakes in her county job and had no knowledge that anything was wrong. But the jury did not buy it. After 3 days of deliberation, they returned guilty verdicts on all counts for both Sharon and Gregory. At sentencing in December, Sharon got 8 years in prison. Gregory got 10. Judge Holloway, who also presided over the criminal case, was harsh in her sentencing remarks. "You abused a position of public trust to prey on vulnerable property owners," she told Sharon. "You stole land that had been in a family for 5 generations. You destroyed the investments of innocent people who bought homes in your fraudulent development. You have shown no remorse and no accountability. The sentence of this court is designed to punish you and to deter others who might contemplate similar schemes." I felt a grim satisfaction watching Sharon Mitchell being led away in handcuffs, her perfect hair finally out of place, her blazer rumpled. It did not undo what she had done, but it was justice. The demolition of the townhomes began in January. It was surreal watching the structures come down, returning the land to something resembling its natural state. The process took 4 months. By May, almost exactly a year after I had first discovered the construction, the land was clear again. Scarred and damaged, but clear. I stood on the property on a warm spring morning, looking out over the fields. The old oak trees that marked the property line were still there, survivors of the whole ordeal. I had brought a metal box with me, containing copies of the land patent, the court documents, and a letter I had written explaining everything that had happened. I buried it near one of the old oaks, a time capsule for future generations of Bradleys. My phone rang. It was Marcus. "Hey, Vincent, I just wanted to check in. How are you doing?" "I am good," I said. "Really good. I am standing on the ranch right now. It is almost back to normal." "That is great, man. So what is next for you?" I looked around at the land, thinking about Grandpa Earl, about Samuel Bradley, homesteading here in 1873, about all the generations in between who had worked this soil. I'm going to build a house here, like I always planned. Going to start that organic farm. Going to make sure this land stays in the family for another 150 years. "You earned it," Marcus said. "You fought hard for it." After we hung up, I walked around the property for a while, just taking it all in. The whole experience had changed me. I had learned things about property rights and justice that I never expected to need to know. I had learned that land patents issued 150 years ago could still have power. I had learned that fraud and corruption could happen anywhere, even in small county offices in Texas. But most importantly, I had learned that some things are worth fighting for, no matter how long it takes or how hard it gets. My family's land was one of those things, and now it was safe, protected not just by fences and survey markers, but by court orders and a land patent that stretched back to President Grant and the Homestead Act. Sharon Mitchell and her brother had tried to steal that legacy, and they had failed. They were in prison where they belonged, and I was standing on Bradley land, same as my ancestors had done for 5 generations. In June, I got my building permits approved and started construction on my house. I hired a local builder who had known Grandpa Earl, a man who understood the significance of what we were building. The house was going to be modest, nothing fancy, built near where the old farmhouse had stood before it burned down in the 1980s. Solar panels on the roof, a well for water, gardens for the organic produce I planned to grow. I also started the process of getting the property designated as a Texas Historic Family Land Heritage Site, a program that recognized family farms and ranches that had been in continuous operation for over 100 years. With the land patent and our documented history, we qualified easily. The designation came with a handsome bronze marker that I installed near the front gate. Bradley Ranch, family-owned since 1873. One evening in July, as the sun was setting over my partially completed house, I got a call from Jennifer, the woman who had bought one of the townhomes. She and the other residents had formed a group to sue Gregory and Sharon's estate for damages. The criminal restitution had covered most of their losses, but they wanted to make sure they got everything back. "I just wanted to thank you," she said. "If you had not fought this, we never would have known we were part of a fraud scheme. We would have been living in homes built on stolen land. You did the right thing, even though it would have been easier to just walk away." "It was never an option to walk away," I said. "This land means too much to my family." "I understand that now. What you did, getting that land patent, fighting through the courts, it was incredible. You should be proud." After we hung up, I thought about her words. I was proud, but more than that, I was grateful. Grateful that I had found out about the construction when I did. Grateful that Marcus had known about land patents. Grateful that Judge Holloway had been fair and thorough. Grateful that the system, despite all its flaws, had ultimately worked. By September, my house was finished. It was a simple 2-bedroom structure with a wraparound porch, built from local timber and stone. I moved in on a Saturday, carrying boxes from my apartment in Austin. The first night I spent there, I sat on the porch and looked up at the stars. The sky was clear, unpolluted by city lights, and I could see the Milky Way stretched across the darkness. I thought about Grandpa Earl, about the conversations we used to have on his porch in Riverdale. He would have loved this house, this view, this moment. I wished he could have seen how things turned out, how I had fought for the land he had loved. But in a way, maybe he did know. Maybe somewhere, in whatever comes after, he was sitting back with a satisfied smile, knowing his ranch was safe. I started my organic farm that fall, planting cover crops to restore the soil that had been damaged by the construction. In the spring, I would plant vegetables, herbs, maybe some fruit trees. I had already lined up agreements with several restaurants in Austin that wanted locally grown organic produce. It was going to be hard work, but good work, meaningful work. The criminal appeals for Sharon and Gregory were denied in November. They would serve their full sentences with no possibility of parole for at least 5 years. I heard through Marcus that Sharon had tried to get her sentence reduced by claiming she had been coerced by her brother, but the judge had rejected that argument. She had been a willing and enthusiastic participant in the fraud scheme, and she was going to pay the full price for it. In December, almost 2 years after Grandpa Earl had died, and nearly a year and a half since I first discovered the construction, I held a small gathering at the ranch. Marcus came, along with Rita and several other people who had helped with the case. Jennifer and a few of the other former townhome residents came too, curious to see the property now that it was restored. My parents drove down from Dallas, proud of what I had accomplished. We stood around a fire pit I had built in the backyard, drinking beer and eating barbecue. Marcus raised his bottle in a toast. To Vincent Bradley, who proved that justice still exists and that land patents are not just dusty old documents. You took on an HOA, a corrupt developer, and a rigged system, and you won. Here's to keeping the ranch in the family for another 150 years. Everyone cheered and drank. I felt a warmth that had nothing to do with the fire, a sense of completion and rightness. The nightmare was over. The land was mine. The future stretched out ahead, full of possibility. Later that night, after everyone had left, I walked out to the oak trees at the property line. I put my hand on the rough bark of the oldest one, a massive tree that had probably been standing when Samuel Bradley first arrived in 1873. It had seen 5 generations of my family. It had survived droughts, storms, and now a corrupt HOA. It was still here, still strong. "We made it, Grandpa," I said quietly. "The ranch is safe. The Bradleys are staying right here where we belong." The wind rustled through the oak leaves, and I chose to believe it was his answer. Yes, we made it. We are home. I stood there for a while longer, looking out over the land that had almost been stolen, the land that was now protected by every legal mechanism I could put in place. The land patent, recorded and recognized by the courts, the clear title, free of any clouds or disputes, the historic family land heritage designation. All of it together formed a fortress around this property, making sure that what had happened could never happen again. As I walked back to my house, I thought about the future. Maybe someday I would have kids, pass the ranch down to them like Grandpa Earl had passed it to me. Maybe they would have kids, and those kids would have kids, and the Bradley Ranch would still be here in 2017, celebrating 300 years of family ownership. Maybe that distant future, Bradley would dig up the metal box I had buried and read about the time their ancestor fought an HOA in court with a land patent and won. The thought made me smile. History was not just something that happened in the past. It was something we created every day, with every choice we made, every fight we fought, every inch of ground we refused to surrender. The Bradley Ranch was history, and it was also the future, and I was the link between them, the guardian of this moment in time. Inside the house, I made a cup of coffee and sat at my kitchen table, looking at the land patent hanging on the wall in a frame. The paper was old and yellowed, but the words were still clear. Know ye, that the United States of America, in consideration of the premises and in conformity with the several acts of Congress, has given and granted, and by these presents does give and grant unto Samuel Bradley and to his heirs the following described tract of land. Those words, written in 1873 and signed by President Grant, had saved my family's legacy in 2026. They had proven stronger than a corrupt HOA, stronger than a fraudulent tax sale, stronger than all the money and lawyers the developers could throw at the case. They were the foundation of everything, the bedrock upon which 5 generations of my family had built their lives. I raised my coffee mug toward the framed patent in a silent salute. To Samuel Bradley, who had homesteaded this land, to all the Bradleys who came after, who had worked it and loved it and kept it in the family, to Grandpa Earl, who had held on until the very end, and to the future, to all the Bradleys yet to come, who would stand on this land and know they were home. The Bradley Ranch was saved. Justice had been served, and I was exactly where I was meant to be, on land that had been in my family for 152 years and would be for centuries more to come. Sharon Mitchell and her brother had tried to steal that future, but they had failed. The land patent, that ancient document signed by a president in the aftermath of the Civil War, had been my secret weapon, my ace in the hole, the proof that could not be denied. Looking back on everything that had happened, I realized I had learned an important lesson. Property rights in America were not just about deeds and titles recorded in county offices. They went deeper than that, back to the fundamental grants made by the federal government when this country was young and land was being opened up for settlement. Those land patents were sacred documents, and they carried weight that modern bureaucracy could not override. I finished my coffee and went to bed, sleeping peacefully in my house on Bradley land. Tomorrow I would wake up and work on the farm, planting seeds in soil that my ancestors had tilled. And the day after that, and the day after that, building a life and a legacy that would endure. The HOA had built 40 townhomes on my grandfather's ranch, but I had pulled the original land patent in court, and that had made all the difference. Justice had prevailed. The land was mine. And somewhere, I was certain, Grandpa Earl was smiling.